Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Welcome back to the Legal Lounge. Attorney Tiffany Byrd with the Modern Legal Team is here to join us today, and we're going to be talking about custody.
Yes, my favorite topic.
I feel like whenever I look at your caseload, I'm like, Tiffany is dealing with a lot of custody cases. So
that's the bulk of it.
Yeah. So we're in your wheelhouse today.
Yeah. Welcome.
Yes.
Welcome. I like to call it Crazy Town sometimes.
Crazy Town sometimes. Mm-hmm. Yeah. That's fitting. So I want to kind of expose the whole process because I know a number of the listeners out there, as well as just, a common person in general is interested in learning more about what do we do with our kids if we're thinking about separation and divorce. Mm-hmm. I know a lot of clients that I've consulted with or just people out on the street have asked me, they're like, how can you even contemplate, sharing children, especially if they're younger, in a divided household? So what would you say are the first things that come to mind when we're thinking about a custody issue coming up for parties thinking about separation or divorce?
I think the very first thing is for you to make your own peace with it because you've got to be stable before you start bringing anything to the kids because they're going to feed off of what energy you're bringing. So if you're stable and you're okay, they're going to have a better chance at being okay. They'll have their own emotions about it, and that's fine. But if you're also super emotional because you haven't made your peace with this transition, it's going to be that much harder for them. So the very first thing is to make your own peace with it. And then after that, if you can, sit with the other parent and just say, okay, listen, how are we going to navigate this? When are the kids going to see each of us? Because if you have that plan solidified for the most part, you can come to the kids with that in this unified fashion, and it again removes some of the fear that these kids are going to be feeling naturally because their world is shifting a bit. And just like adults, they don't like changes they don't know about. So take away as much of that as you can on the front end.
And we're talking about this initial process occurring even before you separate and even before we're talking about separate residences.
Absolutely. Absolutely. Like the more that you can plan for these things, the better it's going to be overall when you get to the other side. I understand that there are some circumstances that you can't plan, but on the best case scenario, when you see this coming and you're like, okay, I'm agreeing that this is what's best, then let's start laying the rest of the groundwork first before you make that next move.
Yeah, that's huge.
Yeah.
So while we're still living together, let's try to individually accept that we're going to be moving forward with a separation. And I like to tell my clients, let's not even talk about the divorce word.
No, don't even bring that up.
Yeah. The legal terms, let's just leave this out of the conversation for quite a while. But if what's healthy for your situation is to move forward with a separation, then come to peace with that as much as you can first. And then try to engage the other parent in this process.
Absolutely.
When would you say is a good idea to involve the influence or even the advice of an attorney?
I think it's always good to have the information so you know what's possible. So get that early on because you may learn that, hey, I'm thinking that this is going to be a pretty straightforward process, so I want to come out maybe guns blazing sometimes.
Yeah.
And then you find out the reality of how this works, and you're like, no, I think I can compromise a bit more. Or me and the other parent, we can create a better schedule than what I'm learning is very possible if we end up in court. So I think having that information lets you make better decisions in the beginning.
Yeah.
So I think doing it earlier rather than later is always going to be better. And then for sure, if you all have reached an agreement, so if you all have come to terms on, when the kids are going to see each of you, how we're making major decisions, who's making those major decisions for the kids, if you've come to terms on all of that, then go ahead and reach out to an attorney and say, listen, this is where we are. We do need some help formalizing this. Can you help with that?
Yeah.
And then it kind of writes itself.
And I'll just say on the attorney side, I love those cases.
I do too. I only
They're my
get them
favorites.
very rarely, very rarely,
Yeah.
but I do love when they happen.
Yeah. And that's to encourage those individuals that if you do have an agreement, let's go ahead and formalize it. Let's make sure it's legally binding. Honestly, not only to protect the parties and the parents, but to protect the children most of all. Because other changes are going to happen in life. That is just life. But if you have this written, legally binding custody arrangement that is your fallback, if you will, when things do get a little difficult or more tension filled, then you have that document to guide you through all of those turmoils that are bound to come up.
Absolutely. I mean, because you're going to have the same arguments, arguably, that you would have had if you were in the same household. Like, you're still two different people. Yes, you're parents, but you probably have different ways of approaching different situations. That's not going to go away because now we're in two separate households. In some circumstances, it may exacerbate it a little bit. So these were always going to be issues that you were going to have to work through as parents. And so to have this document laid out to kind of help, which a lot of people don't have, especially if you're in one single household, there's no guidebook for that.
Yeah.
So, maybe on some circumstances you are a little bit better off
Yeah.
because there is like, hey, we've already decided how we were generally going to handle this. Yeah. And it kind of takes some of that out of it.
Yeah. And that's where attorneys can help early on is to your earlier point, they can help any parent understand how the law works in their state, specifically in North Carolina or South Carolina, but going one step further, how the law will apply to their children, their family dynamics and situation, because every family is unique. Right? Because a household with 3 kids is different than one child. A household with a 16-year-old is different than a 5-year-old, and the list goes on.
Yeah. And I think it can become more complicated, especially when, the children now, they are in a myriad of activities, some of them more time intensive than others, and you're going to have to work through a lot of those challenges. And so I think engaging with an attorney who has had a multitude of experiences with other families that may have had similar situations can use the experience that they got from that to say, listen, these are some things that I've seen come up. These are some of the remedies that other families have used and it's worked. You guys think about that and see if that would be something that would work for your family.
Yeah. And I feel like a lot of people listening right now are probably hearing our comments and they're like, well, yeah, it would be great if I could talk to the other parent. But Tiffany, Theresa, I can't even talk to the other parent right now. Actually, they're a pain in my side. So how do we deal with the situation when parents are not able to actually sit down and have that conversation and go one step further? Maybe mudslinging has already started and some bad mouthing has already started, regardless if it's in front of the children or not.
Yeah. That's why the court is there. I mean, I tend to say that the court is your last ditch option. You try and use that as a last resort. And if things are already tense to that level and mudslinging has happened, or maybe it's not safe for you to have conversations with the other parent, then that's why the court is available to you. And so we can file a child custody claim. In Mecklenburg County, you can request what's called a temporary hearing or a temporary parenting arrangement. If that's granted, then you can get in front of a judge and present, hey, this is what I think is a temporary solution until we get to a final resolution.
Yeah.
Other counties in North Carolina, you can simply once you file, you can ask for that hearing date. South Carolina, Those temporary hearings are a little different. There is no live testimony for that, so it's all documentation. So depending on where you are, how you get to that temporary hearing may be different, but it is available to you if collaborating at the beginning just isn't possible.
Yeah. And go one step further. Even when you file that lawsuit in North Carolina, and I'm not sure in South Carolina, but I know in North Carolina, you are then statutorily required to try to negotiate a custody arrangement with the other parent. Generally, judges will prefer that negotiation effort, court-ordered custody mediation is what we call it, happen before any custody hearings because, as you can imagine, parents know more about their children than a judge ever will. That's why a judge generally will be like, hey, you guys try really hard, please, to resolve it yourselves because judges themselves will admit, I don't know your kids like you do. And so there is the requirement of that mediation process. Is that the same in South Carolina by chance?
It is. Okay, it is. So both sides of the state line follow the same general procedure on that.
Yeah. And so with that court-ordered custody mediation, parties are in a way forced to show up and sit down and at least try to talk. On the flip side, court-ordered custody mediation may not result in a resolution. And generally, I see it running into issues because at that court-ordered custody mediation, at least in North Carolina, first off, you can't have attorneys present. So if you have a legal question, you are hearing crickets because there's no attorney there, one. And then two, normally it's limited in terms of time and effort, meaning sometimes it's kind of looked at like we have to check this box versus actually investing the effort into, okay, both parties coming with their certain understandings and desires and being open and willing to talk about how they can, first off, pursue what they want, but also factoring in the needs of the children and the desires of the other side. And that's very hard to do in a court-ordered setting. So we generally also encourage individuals, especially if they retain us as their attorneys, to do a private mediation, which we can schedule more conveniently for all parties and actually sit there until we hash out a resolution.
Exactly. Yeah. Like for North Carolina, court-ordered mediation, I think, is limited to 2 hours at most. And you don't get the benefit of having the knowledge of an attorney sitting next to you, not only for the legal purposes, but also, again, we've worked with a number of families and seen a number of situations. So the information that we gained from those experiences, you don't have at the table with you. So you may be coming into this mediation thinking, okay, I know what I want on a week-to-week basis, and I know what holidays I want, but I haven't thought at all about how this is going to transition as they get older. What are the situations that maybe I'm not thinking about right now that the mediator isn't going to bring up? The other side isn't really going to bring up either. And so you get done and there's still this gap that you didn't know existed until you get to the gap. And you're like, well, now what do I do? So,
and actually, speaking of gaps in custody arrangements, I've seen a very large gap in what we call legal custody. So legal custody is essentially decision-making authority over anything affecting the child's welfare. So physical custody has to do, okay, where is the child physically on Monday nights, Tuesday nights, and so forth. Legal custody is, well, who gets the decision about the child's pediatrician or dentist or teacher in school? And those decisions, especially if you've just separated, a lot of people are like, oh, well, we'll just keep status quo. I'm like, well, status quo only goes so far because guess what? That child is going to graduate from elementary school and we'll go to middle school or high school. And we have all these other influences like extracurricular activities, or maybe the child has a certain need such as, ADHD or, heaven forbid, a car accident occurs and they need physical therapy. And these are all decisions that affect the child's welfare. But what I see, especially from court-ordered custody mediation, is that it's a one-liner that says the parties have joint legal custody. And that's it.
And you're like, well, okay, but what does that mean? How does that function in my life? I don't know what that looks like. So,
and I love when they come to me, they're like, what does this mean? I'm like, that's a great question because
I don't know. It could mean a lot of things.
Exactly. It could mean a lot of things. And generally what it actually means is that the two of you have to work together about these joint legal custody decisions.
Yep.
And a lot of clients are like, but we
can't.
we had a dispute. That's why we went to court.
Right.
That's why it was filed in the law. The lawsuit was filed in the first place.
Yep.
So it is very interesting where even when we have these mechanisms to try to help families, such as the court-ordered custody mediation process, which it is a great program.
Yes.
It does help a lot of individuals and parents come up with that physical arrangement. Those holes do come about because it's not as detailed as it could have been.
Right.
And you don't want to know when your child is in the hospital who gets the final say over certain medical decisions.
Exactly.
You want to deal with that early on.
Right. Right. Or what we see quite often, and like the example you gave, in that scenario, there may not be any one person that has that final decision. It's just assumed that you two will come to a resolution between yourselves. And it's like, yeah, but we've already engaged the legal system, which kind of implies that we can't do that all the time.
Yeah.
And so it really does leave a lot of families, a lot of parents in a very difficult situation at probably some of the worst times possible.
Yeah. Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other, but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal Services at modernlegalnc.com. So if you're listening to this episode and you have a custody order or custody agreement, feel free to take a look at it. Make sure it's pretty detailed. And if it's not detailed, reach out to a family law attorney to see what your remedies may be, because maybe it is we go one step further and still negotiate a resolution, but have a more detailed agreement or consent order versus just the one-liner of joint legal custody.
Right, right. And sometimes it doesn't necessarily have to be that you're saying something's wrong with the other person and that's why you're trying to make changes. It's just, hey, we've sat with this order for a while and we've noticed some things that, tend to constantly come up, and maybe we can find a better solution to it. So let's make, a small adjustment or a minor adjustment to it. And let's come to terms on what that adjustment looks like. It doesn't have to be contentious just because we're saying, hey, listen, there's still some gaps that we need to cover.
Yeah. And in fact, I think when there is clarity, that not only provides more stability for the children, it actually provides more direction for the parents. So it's like, great, I don't have to go to the other parent every time I want to, I don't know, buy soccer gear, right?
Right, exactly.
It's things like that.
Yeah. And that will reduce the tension between you and the other parent as well, which I guarantee you is going to trickle down to the kids. They are going to feel that shift, which I'm hoping you would feel that shift, oftentimes I do, because another thing that I get a lot is parents will call and just say, well, my kid is just so upset and they don't want to do this and they don't want to do that. And some of it is purely from their own situation and their own, trying to process what's happening. But 9 times out of 10, it is coming from them feeding off of the energies that they're getting leading up to exchanges or leading up to events where they're like, I think both parents are going to be here. Oh, they don't do well together. And that kind of stirs up a lot of feelings for them. So any way that we can reduce that between the parents is going to make it better for the kids.
Yeah. So let's say parties tried to resolve it before they separated, the custody arrangement.
Yep.
Did not work.
Okay.
Someone files a lawsuit. They go to mediation, whether it's court-ordered or voluntary. Still no resolution. They ask the courts for a temporary parenting arrangement or temporary custody. There's a Band-Aid.
It's not great.
It's not great for anyone.
Nobody likes it.
No.
Everybody's upset.
Exactly.
Yeah.
What happens then?
Well, because there hasn't been a final resolution, we essentially submit ourselves to the court and say, all right, we need availability for a trial.
Yep.
And then you get in line and you wait
Yeah.
until there is space available with the judge that you've been assigned for the amount of time that you've determined your case needs to be heard. And then we wait until that date. And until that time, you follow the temporary order that nobody likes. Or we can try to negotiate some more, because you're always able to do that. In fact, the courts really, really encourage you, try as many times as possible so that I don't have to make this decision.
And getting a little granular here, the way it actually works when I'm opening the curtain, if you will, into the litigation court side is literally the court gets notified that you have not resolved things at mediation. We get put on a list. We get scheduled for a calendar call. And at that calendar call, at least here in Mecklenburg County, it's generally at least 40 to 50 cases that are being scheduled for a 3-week trial term. However, one of the 3 weeks is already filled with other things. So you have approximately 10 days to resolve 50 family cases, and not just custody. So we could be resolving alimony issues, equitable distribution issues, maybe some contempt issues, maybe some modifications, maybe there's even some domestic violence related matters in there. And so if the listener is saying, how can you resolve 50 family law cases in 10 days? The answer is you cannot.
Correct.
So what we see from the attorney side when we're scheduling things is hopefully some of those 50 cases have reached a resolution, to your point that you just made, where the negotiations are always continuing if they can. And maybe they've reached a resolution before the calendar call. But a lot of those cases will not have resolved. And if you're in the top 10 cases, if you will, and they say, I need 1 day, I need 2 days for my trial, then that means the rest of us, if we're further down the list, we get pushed to another calendar call. And it could be some of the cases request a continuance, and they do request to be pushed because maybe there's outstanding discovery, or maybe they're bringing in a child therapist that needs to do some evaluations, or maybe someone's just out of town for those weeks. And so when all is said and done, I will say, I generally tell my clients, we are not likely to be scheduled on that first calendar call, which, by the way, we got the date for this calendar call 3 to 5 months ago.
Right.
So we're going to be pushed again, possibly on a good day, maybe only 2 months out, but I've seen longer than that. Right.
Yeah.
And then when you go to calendar call, then you're scheduled for a 3-week trial term, which is a number of weeks after that. So when I tell my clients, a case, if we file today, hopefully we'll have a final resolution in the next 2 years. And I see the deer in the headlights look from my clients.
They're like, what do you mean?
What do you mean 2 years?
I'm like, I'm not doing this to try and push you to settle outside of this. That's just the reality of how this operates.
It's because of that whole system, the calendar call system.
Yep.
And to your earlier point, the fact that you have to get in line, and there's just so many family law cases. In Mecklenburg County on the 8th floor. Go ahead, check it out if you're here in Mecklenburg County. It's nice because it's the floor that has all the nice paintings on the walls.
It is. It's a beautiful floor. I do like it. But
they did great with the interior design. But all those courtrooms are family related or juvenile related, right?
Yeah.
We actually have so many family courts running that we have another courtroom for just family law cases on another floor. So when I say our family courts are busy and we have a number of cases running through the family court system, you can go see it for yourself with just the sheer number of cases being handled on any given day.
Yeah.
And so that's another thing to consider, even before you separate, is do I want a custody case that may resolve itself within 2 years, maybe longer, maybe longer at the offset? Like, do I want to start this process? Or is there something I want to negotiate earlier on? I'm willing to be a little flexible on, even if I don't like it.
Exactly.
I'm still okay with it.
Right. And I think that's a really good point to keep at the forefront when you're going through this. You are not going to like really anything about this. And that's not the point, honestly. The point is there a setup that we can create that we can live with, that we can manage for the long term? Because that's ultimately what you're going to want to hone in on. You can tailor it specifically to your family, which is something that you are not going to get if you step onto the 8th floor and look to that judge to say, but listen, I need you to know every little intricacy about how my family works. They are going to politely tell you that they don't have the time for that. So as much as we know that every family is different, unfortunately, the way that our system has to be set up, we don't get to be super individualistic in the solutions that are created by the judges.
Yep.
Surely because of what they have coming at them and what they have to manage. So if you want something that's very tailored to your family, then you have to create it.
Yep.
Which means you've got to get buy-in from the other person.
And you have to create it outside of a courtroom.
Yes.
I remember I
Yes.
went up to a judge one time, and she had been recently elected, but prior to being on the bench, she was a family law attorney. She was one of us. And I remember going to her, and I just asked her, I'm like, what is a challenge that you see now that you're on the bench that you didn't realize would be a challenge? And her response was actually very, very specific. And she said, Theresa, honestly, it's that I have so many bounds within which I have to function. I have to act. I can no longer be creative. I can no longer go outside these guardrails, if you will, to really do what's best for a family. These laws, specifically because she's a judge, she has to stay within. Yeah. And that could be what you and I would think of, oh, it's pretty standard provision, but it's not for a judge if they have to follow certain laws and requirements.
Yeah, that's true. And I think it would be interesting just to kind of hear from a judge's perspective, like, hey, I know you think that I have all of this power, but I need you to understand what limited power I really do have. And I think it would be very eye-opening for people considering coming into this realm, saying, listen, okay, my family does need assistance, and I'm thinking that the court is the end-all, be-all for that, right? But maybe it's not. Maybe it really truly is between me and the other parent.
Yeah.
That's where that solution lies. We just got to figure out how to get to it.
Yeah, yeah. And some of these tools that we can bring in outside of the court system could be the make or break for what the parents actually want. So I'm also a certified mediator, and recently I had a mediation, and it was about custody. And I thought this was so interesting because mom wanted to put the child into therapy.
Okay.
Father wanted to put the child into therapy.
They couldn't agree on the therapist?
No,
Or the type?
this was the great part.
Lord.
Dad was accusing mom of not sharing with him the information of the therapist that she had already investigated. Mom was accusing father of not reading the emails that she was sending regarding the therapist. I, honest to God, to this day, think the emails just weren't received. And so we're arguing about putting a child into therapy when really there was no argument.
Right.
There was just this facade of discord when at the end of the day, when I said, hey, mom wants child in therapy too.
Yeah.
Dad wants child in therapy too, like to the opposing sides. Everyone's like, thank God we finally have an agreement. And I'm like, I didn't even do it. You
You're
both
like,
already wanted
yes,
it. Go one step further, a judge wouldn't have been able to order therapy in that specific situation, legally speaking.
Right.
Yet both parties clearly wanted it. And it was great because I did look pretty good that day when I brought
like,
about resolution.
I'm so glad you all came.
Go mediation skills, right? But that's like a perfect example where it's like the parents can get creative and have a final say. It's just figuring out what is the discord, what is the problem, because maybe the actual problem, i.e. an unreceived email, is a non-issue.
Right.
So let's utilize the tools that the judicial system does have, such as attorneys and mediators and staying outside of court so that we can find a resolution that it looks like maybe everyone wants.
I try and persuade people as much as possible. Like, please, we will go to court if we absolutely have to. That is one of the avenues that we have, but I want to make sure that we have explored all of the other ones first.
Yeah.
And then let's really start talking about, okay, what are your biggest concerns, and tell me why you have them. And then let's start figuring out, all right, are there other things that we can put in place to address those concerns?
Yeah. Yeah, that's huge. So we've gone through all the negotiation mechanisms possible. Parties end up in front of a judge. A judge issues a final child custody order. What happens then?
Well, you try and follow that order.
Yeah.
But life continues to happen.
Yep.
And I am sure that something's going to come up where you're going to come back and look at this and say, this is no longer appropriate. But it says it's a final order. So what am I supposed to do about that? Well, when it comes to kids, nothing's truly final until they hit 18. And then all bets are off. Then it's its own thing. But if you do come up against a problem that involves the final order that you have, we can come back to court and say, hey, judge, some things have changed so much so that what we had back then no longer works or is no longer appropriate, and we need you to take another look and make another decision.
Yep. And so you would file a motion to modify child custody. And it's interesting because a lot of people think that it makes sense when I say that a child's needs change as they grow up, right? Like a 3-year-old's needs are very different than a 6-year-old's, than a 9-year-old's, and a 16-year-old's, right?
Yes.
And so that makes logical sense. From a legal perspective, though, that means we're relitigating child custody. What does that mean? Well, for all you law nerds out there, what that means is child custody is the only course of action that you can come back to court more than once, more than twice, more than 3 times, and relitigate the same substantive issue. Exactly. Exactly. The same base issue, i.e. this child.
Correct.
That's the only cause of action in our court system where that's possible, right? Because in criminal, you get
one and done.
One and done. Double jeopardy. Can't be charged again with the same crime, right? Equitable distribution, even property's divided. That's it. Ownership has changed.
Yeah.
Whereas when it comes to our children, we can come back again and again. Now, granted, the courts and the laws have a number of rules surrounding that.
Yes.
So it's not like you can get a custody order today and change it tomorrow.
Right.
There has to be a substantial change of circumstances. But to your earlier point, if something, especially if years have passed, a number of years have passed, a custody order can be modified. And I've seen that. In a couple of my cases.
I've seen quite a few of them. But yeah, and on some level, I think that does need to bring some peace to it. But I also think you need to recognize that it's not that you just get to change it on a whim. So whatever you get in that order, we need to make very sure that it is as close to what you can realistically control and follow as long as possible. Because you may not be able to just come back and say, oh, well, that doesn't work anymore. The reason why it doesn't work is really important. And that reason needs to be pretty substantial.
And I will say, I'm going to put my litigator hat on. Please follow the order.
Please do.
Until it's modified. Just because you have a reason to modify it doesn't mean you can
just go ahead and do it.
Exactly.
No, you've got to go through those processes, because if you don't, you could also very likely going to get in trouble for not following the order that was already in place.
Yep. And there's always the possibility that if you open up that Pandora's box and say, hey, judge, we need a change, that judge may very well agree that a change needs to occur, but not in your favor.
Right. Like, I agree, there does need to be a change. Not the one you're asking for, though.
Yeah.
One that I see as appropriate.
Which, by the way, that is within the judge's bounds to do.
It is. It absolutely is.
Yeah.
Yeah. Which can be a pretty big shock to the person. Like, well, I asked. And I'm like, you did ask that they relook at what's going on and how this is affecting this child. And the judge felt that the changes that they've seen require this type of adjustment.
And because you haven't resolved that issue amicably between the parents, that issue is now going to that stranger, that judge.
Correct. Yep. Who, of course, is not going to have all of the backstory that either of the parents have naturally. There's no way for them to.
Yeah.
So I can guarantee, if nothing else, that what they think is important and what they decide is not going to be what you would have done.
Yeah.
to me, if they're on better terms and they can collaborate and talk more, ideally, then you all have talked about what the issue is and have developed your own solution. And now we're coming to attorneys saying, hey, we need you to formalize this adjustment that we've made. But if we're not quite there and we're like, I think we can do it, we just need somebody else like a mediator to be in the middle, then we can return to mediation, try and get a final agreement on what those terms are, and then present that to the judge for entry.
And going one step further from a procedural standpoint, if everyone agrees that a change needs to be had and either we're close or we've already come to a resolution, from a procedural standpoint, we don't even have to tell the courts anything until we have that final agreement.
Right.
And trust you me, a judge is going to sign any and all consent orders that come across the table, especially when it's with regard to children.
Happily.
Yes.
Happily.
So
You're
you
like,
don't even,
great.
And procedurally, actually, we're kind of on the fence on this one, but generally we go ahead and file a motion to modify, but it'll be a friendly motion just saying, hey, judge, please enter this consent order. And we can make that real easy on our side.
Yeah.
The harder part is resolving that
Correct.
issue or the changes that have occurred since the permanent order.
Yeah. I'd say, so the general framework of how the custody action happens doesn't really change much between if it's an original or if we're trying to modify something. You can go through all of the same processes.
Yeah, but you can leave the boring civil procedure stuff to the attorneys. We'll take care of it.
We don't even really like it.
Yeah,
so
yeah. Civil procedure, I tell people all the time, that was my worst grade in law school. And lo and behold, I know it like the back of my hand now.
Listen, there's a lot about law school that's just traumatic. So just leave it alone.
So on that note, thank you so much, Tiffany, for coming back to the Legal Lounge. And I'm glad we were able to walk through some of these child custody issues because I know that is a hot topic out there.
It is. And rightfully so.
Yeah.
Rightfully so. It's important. So, yeah.
We'll see you next time. Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.